Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Rob Moulton, a partner in Latham & Watkins' London office. In this episode, part of a 10-part series complementing our 10 key focus areas for UK regulated firms in 2024 report, we discuss investment research. This is a crucial piece of the MiFID reform agenda, and the unbundling proposal around investment research proved very controversial when introduced. The FCA was seen as one of the architects of this measure, and it required asset managers to pay for research rather than acquiring it as part of a bundled research commission. To discuss this, I am joined by Giulia Pecce, Head of MiFID Policy, Research and Wholesale Investor Protection at the Association for Financial Markets in Europe, AFME. Giulia, welcome to the podcast.
Hi, Rob. Thanks very much. I'm delighted to join you today to discuss such a topical issue, which is of great interest to our members and to the market as a whole. We have been very busy over the past year, observing and contributing to developments on investment research across key jurisdictions, particularly the UK and the European Union.
So let's start with the UK then, Giulia. I mean, how does AFME look at the policy proposal to scrap the unbundling rule? Are you supportive of it? And how have you engaged with the authorities here in the UK?
So there is certainly a long history behind the unbundling issue, which was originally introduced by MiFID II, so on the 3rd of January 2018. This change sparked substantial debate at that time. We, the sell side, had strong reservations that the unbundling changes were going to address the stated policy objective. As you just said, as one of the key features of the unbundling regime introduced by MiFID II is that to meet unbundling requirements, asset managers had to change the way they paid for research. However, the new reporting requirements under MiFID II were seen as being too operationally cumbersome, and, as also reported by the FCA back in 2019 in one of their multi-firm reviews, most traditional asset managers have opted to pay for research using their own resources, so via P&Ls, instead of using their clients' funds. So, the erosion of the buy-side's budgets drove two main issues. Firstly, asset managers to be more selective with procuring research. Smaller fund managers in particular had to consolidate research consumption in response to the increased operational costs and complexities associated with MiFID II compliance. The second issue was that the reduced budget also drove a reduction in the seniority and experience of some sell-side research analysts and salespersons. For example, based on a CFA UK assessment of April 2019, as a general trend, many, but not all sell-side firms pared back analyst numbers, merged teams, and reduced analyst seniority. Having said that, going back to your original question, as usual, the industry has adapted to the regulatory environment. And considering that MiFID II came into force relatively recently, there was certainly, at least initially, a resistance to the idea of having to undo what had recently been implemented. That sentiment was perhaps predominant at that time, and we talk about Q4 2022 when the Edinburgh reforms were announced in the UK. There was quite a bit of regulatory uncertainty about how other jurisdictions were looking at similar issues. Our members are supportive of initiatives which seek to improve investment research in the EU and the UK, so that it can contribute fully to supporting their position as highly attractive venue for new listings. So, to finally reply to your original question, what I have observed, particularly as the negotiation as part of the EU Listing Act have evolved during last year and continue to evolve, and the US SEC have confirmed their approach in the summer of 2023, the industry is welcoming a level of regulatory convergence across key jurisdictions. Investment research is inherently global in nature. AFME members tend to produce globally branded and distributed research products. This convergence has been a key factor in looking at the UK proposals under a more positive light. The industry, and I can speak for the sell side, of course, is keen to contribute to the debate to ensure that the future rules are fit for purpose. We want to be constructive and we want to be collaborative.
And Giulia, with the trade associations, is there broad agreement with counterparties like the IA on the buy side as to the direction of travel? Or will the authorities have to figure out that different people want different things from these reforms?
I think broadly there is a sense of alignment, at least in principle. I think buy side and sell side are aligned that more flexibility in the form of additional increased optionality is a good thing for the industry. And I think there is a general sentiment that this is the way forward. The industry is prepared to embrace the change collectively. However, and I think we share the same concern, more than concerns, I think we share the same vision that the new regime should not be overly cumbersome or onerous, particularly from a reporting standpoint. This was precisely the problem that the industry had with previous changes in MiFID II, and ultimately this led to non-implementation. So this is one of those cases where we agree in principle, and I think the proposals in the UK, they will have to be formulated in details, but the EU are looking at similar issues at the same time. I think there is an agreement in principle, but certainly the way the regime is calibrated in practice, that's what we need to monitor, and that's where we need to contribute. That's where we can be impactful.
And when we think of the EU reforms, they're acting at a similar time with a similar mindset, but do we think, is it as clear where the EU reforms are likely to land, or what do AFME makers make of the EU reform agenda in this area?
So I think there are two aspects of it. There is the procedural aspects and then the more substantive issues around it. Certainly, the EU and the UK are looking at similar issues at the same time. However, the timeframes are, to an extent, will be misaligned at some point. So in terms of where we are in the process of the EU Listing Act, as we speak, negotiations are now moving at very fast pace. So we are observing a commitment from member states and European Parliament to achieve a final deal by February-March 2024. This will then be followed by juris-linguist or lawyer-linguist review and publication in the official journal. I suspect this will all happen within the current mandate of the European Commission. For the entry into force, usually legislation in the EU, as you know, enter into force 20 days after publication on the OJ. And as the EU Listing Act is amending a MiFID, which is a directive, then we should expect a period of time for member state transposition and application. This is normally 12 to 24 months or somewhere in between. So that's why I was saying potentially there will be a misalignment in terms of implementation timeframes because of this timeframe, it is possible that the UK rules on increased payment optionality may come into force much earlier than the new EU rules on investment on additional payment optionality. In terms of more substantive issues, in their impact assessment accompanying the EU Listing Act, the Commission stated that while there is no consensus on the underpinning causes, the decline of investment research is objectively recognized. So there is between the Edinburgh reforms and the Kent report and the EU Listing Act, there is a recognition of a problem. And I think that the policy outcome is very similar. However, the details of the proposals might differ to some degree. In the European Union, as part of the EU Listing Act, there are 4 key issues that are being discussed. The first one is the market cap threshold. The second one is increased payment optionality, which we just discussed in relation to the UK side of things. The third one is the EU research marketplace. And the fourth one is the issuer-sponsored research, particularly in relation to a new code of conduct. On the market cap threshold, the Commission has proposed to increase the threshold from 1 billion to 10 billion to boost research for SMEs, including mid-cap segment. However, both co-legislators have proposed the outright removal of that threshold. And that was, of course, in the context of discussions around increased payment optionality, which started to really take off around April last year. And it is therefore very likely that the Commission will promote the co-legislator's position, given there is an agreement there, and also would be more aligned and consistent with proposals around increased payment optionality. With this in mind, AFME is very supportive of the market cap threshold removal. The second issue is increased payment optionality, which is another key element of the EU package. This wasn't included in the original proposal of the Commission in 2022. However, around Q2 last year, it became clear that the SEC was not going to propose a delayed expiry of their non-action letter. Eventually, the non-action letter expired at the beginning of July 2023. At that point, the optionality debate in the EU had already intensified and culminated with the Council text, which introduced proposals in that sense. The Parliament, in their final report, has maintained the optionality concept in principle, but their proposed regime is more granular and prescriptive compared to the Council drafting. So, given co-legislators agree on the principle of increased optionality, it is safe to assume that optionality will be maintained in the final text. We think that this is a good outcome in theory, but as we discussed earlier, we need to see how this will be calibrated and defined in the operative provisions and the recitals, so in the final text.
That's interesting, Giulia. So firms will have to deal with rules changing at slightly different times and in slightly different ways, even though the policy objective is broadly the same.
Absolutely. I think it is one of those issues where a level of convergence is needed, and this is certainly what AFME, as the trade association for the sell side, is advocating for. We are observing certainly more formal communication channels between policymakers, amongst policymakers in the UK and the EU. So there was, as you know, also the establishment of a recent EU-UK regulatory forum last year. The first meeting happened, I think, in Q3 2023. And I think that's very reassuring, and it's a very positive development because we know they are talking, we know that they are formally aware of each other's proposals, and so that there are good and effective communication channels. And as a pan-European trade body, this is obviously very important to us.
Well, let's just leave Europe for a moment then, Giulia, because if we have convergence, we also have the US. So to what extent do you think the US approach will impact upon practices in the UK and the EU?
So there is quite a bit of interesting background around this one. Ahead of MiFID II go live, we became aware of a clash between SEC rules and the MiFID II proposals. Under SEC rules, broker-dealers are prohibited from receiving hard dollars for research. And in fact, in the US, for SEC regulatory reasons relating to the research provider, asset managers typically pay for sell-side research through bundled client payments for broker commissions and research, the so-called soft dollar arrangements. This is effectively the reverse of the MiFID II position, requiring research payments and commission payments to be unbundled and requiring recipients of research to pay to avoid being induced. So in the US, if a broker-dealer were to receive direct hard payments for research, they would be required to register as an SEC-regulated investment advisor, so-called RIA. Becoming an RIA has fiduciary implications. There exist a variety of perspectives on the correct legal interpretation, and this is all depending on any given firm's organizational structure. To resolve these conflicts of law between the SEC rules and MiFID II unbundling rules, the SEC staff issued relief in the form of a no-action letter to permit broker-dealers to receive separate payments for research without being subjected to regulation as investment advisors. Eventually, the letter expired in July 2023. Some firms will have opted to register as RIAs. Others will have identified other legally compliant ways to work around the expiry. In any case, going back to your question, our perception is that, once again, this has been one of those cases where the industry has adapted to the challenges of an ever-evolving global regulatory environment.
That's great. And thank you, Giulia. It sounds as though 2024 will be quite a year for MiFID and MiFID research, in particular at AFME, with those developments around the world. Good luck keeping up with them.
Absolutely. We will be very, very busy on investment research as well as many other MiFID-related files. So looking forward to another very busy years.
Great. And thank you for taking the time to join us. And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of our podcast at lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever else you get your podcasts. And if you'd like more information about the topics in this podcast, or to access our 10 key focus areas in 2024 report, please visit the links located in the show description. And we hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.